From the nation's capital, the American Enterprise Institute for Public Policy Research presents Public Policy Forums, a series of programs featuring the nation's top authorities presenting their differing views on the vital issues which confront us. Today's topic, the Medical Malpractice Dilemma.
I'm Peter Hackett. If you've been to a doctor lately, or even if you haven't, chances are you know that medical fees are going up, and it's not all inflation. Physicians are having to pay the highest medical malpractice insurance premiums in history. In some cases, the premium is so high, it totals more than a young doctor could possibly earn in his first year of practice. Some insurance companies have dropped medical malpractice policies. Some doctors have decided not to carry such insurance. What is behind the malpractice dilemma? Why are physicians being sued for about $2 billion a year? Do soaring insurance payments indicate a rise in medical incompetence? Is there an increased tendency, perhaps, to sue doctors because of the large judgments that have been awarded? Is there a way to reverse this trend? Is there a role that the federal government can and should be playing? Can the legal profession or judges help out? Is no-fault insurance possibly the answer? Welcome to another Public Policy Forum presented by AEI, the American Enterprise Institute, a nonprofit, nonpartisan research and education organization. Today, 4 experts will discuss the topic, the Medical Malpractice Dilemma. Appearing on the panel are Otis R. BOWEN, Governor of Indiana. Governor BOWEN is also a physician. As Indiana Governor, Dr. BOWEN has been instrumental in proposing malpractice reform legislation. In 1973, Dr. BOWEN became the first to receive the American Medical Association's Dr. Benjamin Rush Award for citizenship and community service. Richard Marcus, a judge in Cuyahoga County, Ohio. Judge Marcus is a member of the American Bar Association's Commission on Medical Professional Liability. He is a member of the National Commission on Medical Malpractice of the Department of Health, Education, and Welfare. Jeffrey O'Connell, an attorney, professor of law at the University of Illinois. Professor O'Connell has authored many publications on malpractice and no-fault insurance proposals. William Schwartz, a physician, professor of medicine, and Vannevar Bush University professor at Tufts University, Massachusetts. He is currently conducting research on malpractice. Moderating the discussion will be John Charles Daly. Mr. Daly spent many years as a newsman, commentator, and news executive for both CBS and ABC. Now, here is Mr. Daly.
This public policy forum, part of a series presented by the American Enterprise Institute, is concerned with the medical malpractice dilemma. A dilemma may well be exactly the word to describe the nature of the malpractice problem. One Webster definition of a dilemma is a situation involving choice between equally unsatisfactory alternatives. Now, designated a major national issue in the Nixon 1971 health message to the Congress, the malpractice problem was confronted with an HEW-established commission to study that subject and to make recommendations. A member of this panel, Judge Marcus, who also served on that President's Commission on Medical Practice, wrote of the Commission's findings and conclusions the following. Commission votes varied from a bare majority to unanimity. They adopted 110 separate paragraphs of findings and recommendations, while rejecting several times that number of alternative findings and conclusions. Well, since that undeniably important first step, the confusion is compounded. The medical malpractice crisis has been described as a medical delivery crisis. Charges of legal malpractice, legislative negligence, and juridical malpractice fill the professional journals and spill over into the public media, and the layman finds his understanding as he can of these complex issues in scandal headlines, strike threats by doctors, insurance rate increases allegedly of 500 to 1,000%, and the certainty that in the end he probably will pay the piper. Well, hopefully there is light as well as heat after more than 5 years of earnest investigation and debate. This roundtable seeks to shed light on the causes and the cures of the medical malpractice dilemma. Governor Bowen, to begin at the beginning, why has the issue of medical malpractice become a crisis issue all of a sudden?
Well, I think it's become a crisis issue simply because more suits have been brought against all of the healthcare providers. More have been brought simply because we are, I believe, living in a consumer's revolt time. The public hears and the public reads about miracles in the field of medicine, and they've begun to expect these type of miracles to be performed in every occasion. I think also they tend to equate a poor result with neglect or malpractice when often that is not the case at all. And I suspect there's the feeling that the physicians are affluent and the present day physicians perhaps are a little more cold and impersonal, and they feel that perhaps the physician deserves to be sued. But I think the crisis itself is caused by the fact that the premium cost to the physician has gone way up, and along with that, the many companies that write malpractice insurance have quit writing it, so that the cost is not as great a factor perhaps even as the availability of the malpractice insurance for the physician himself. And as a result, many of the physicians were quitting practice. The insurance companies were quitting writing it because it was not anymore a profitable business. And the patients were paying more as a result, and the availability of medical care to the patients was disappearing because many of the physicians were simply quitting practice.
Judge Marcus, when practice becomes malpractice, a judgment has been made. Are standards established in the courts adequate to judging malpractice in so complex a discipline?
Actually, they're no different here than they are in a great number of other areas. The method by which the courts use to determine whether there has been a basis of legal liability is the same for liability of a physician as it is for a lawyer, an engineer, an architect, or a variety of other professions. And that is that the care should not fall below reasonably careful conduct by someone in that profession. And for the most part, that standard is set by other members of the same profession. In most courts, it is necessary to have another member of that profession state that the standard is some particular conduct, and that that conduct was not done or that standard was not met in this particular situation. So that although there are a few rare exceptions, for the most part, the professions set their own standards in the courts. The issues are actually considerably less complicated than we see in many other areas of litigation. Patent litigation is certainly much more complicated than medical professional liability litigation, and I can suggest many, many other areas. So I don't think it's a problem in terms of the difficulty of deciding the issues. It is an issue that is decided by the profession as its witnesses may appear before juries or judges that decide which to accept and which to believe. The same kinds of decision process that are made for millions of other kinds of cases, millions of other cases, many, many varieties of the less and more complicated kinds.
Dr. Schwartz, the malpractice dilemma substantially turns upon the number and size of awards in these cases. Are these awards excessive? What do you think needs to be done?
Well, there's certainly been a good deal of discussion about excessive awards, but the facts don't seem to bear out the concern. In the American Insurance Association's study of 1974 claims closed, there was a finding that on average there was a slight undercompensation using a loss of earnings and medical expenses as the reference point of the appropriate level of payment. Slightly higher than expected or appropriate payment for the few individuals with large awards and less than the losses to individuals with small awards. So that I have a rather strong feeling that that issue has been overemphasized. I would like to comment briefly, if I may, about another aspect of the compensation problem. If one reads the discussions in the press and listens to TV reports on compensation, one would be left with the very strong impression that the dominant purpose of the liability system is to compensate the patient, that issues of fairness and equity to the injured party is really the central purpose that the liability system deals with. I'd like to suggest that that approach and that attitude ignores a very major additional impact of compensation under the liability system, and that is the impact on the physician. And in talking to my colleagues, every physician that I speak to in a community hospital or at a university hospital indicates that they are responding to the larger number of suits and the increased size of awards with a greater degree of care. In other words, I would suggest, and I'm not the first to suggest this, that the malpractice system has as one of its major purposes a mechanism for quality of care control, a mechanism for improving quality of care. Now, to just close this point out, the question then is, how well is the system working as a quality of care mechanism? Theoretically, in a perfectly functioning system, we would like to have every major malpractice incident result in a claim. This is from a public policy point of view. Only then would a physician, myself, as I go on ward rounds, know that a lapse from the appropriate standard of care is likely to cost me something in both embarrassment, time, and money. And if we look at the HEW report that was mentioned just a moment ago, we find that there are many more malpractice incidents evident in hospital records when reviewed by expert clinicians than there are malpractice suits. So I would like to raise the totally heretical point of view that the increase in the number of claims may not be inappropriate. That, in fact, what we may be doing is seeing a better signal to physicians, to me, to be careful than in the past, and that before we tinker too much with the system, we'd better understand its implications for quality of care.
All right, Professor O'Connell, for 10 years, you have written and exhaustively examined the fundamental relationship between injury and failure of products and services and insurance. Why this massive malfunctioning, as a layman, I think, would see it, in this relationship between medical practice and insurance?
Well, let me start out by saying that I couldn't disagree more strongly with either Bill Schwartz or with Dick Marcus. I think they're both dead wrong.
That's good.
I think if you look at the tort liability system, anybody who looked at it with a modicum of impartiality saw 100 years ago that it was disaster, ultimate disaster. But the point is that accidents are inevitable. And to spend huge sums of money, most of the insurance dollar, on insurance overhead and legal fees, to argue back and forth as to whether a doctor made a mistake or whether a motorist made a mistake or whether an employee made a mistake in getting injured, was seen 100 years ago to be a disaster for purposes of industrial accidents. The only surprising thing is why it took us 50, 60 years to see that the same thing is true for auto accidents. We are now recognizing that. And no one pretends that workers' compensation is perfect. No one pretends that auto no-fault is perfect. They're just perfect when you compare them with the tort liability system. And I suggest to you that we are now seeing the same phenomenon applicable to products liability, to municipal liability, to medical malpractice. I'm delighted that Bill Schwartz is broad-minded enough to think that all this accusation of the medical profession excites better medicine. We ought to abandon the tort liability system, just as we did for industrial accidents 100 years ago, as we're now doing for auto accidents. It's going to be trickier to work it out. But to look upon this system as the judge does is relatively simple. You know, well, did a doctor make a mistake? Well, it's like deciding whether a lawyer made a mistake. I'm a lawyer. Deciding whether I made a mistake is very complicated business. And so I suggest that... I suggest that what we're seeing is simply another manifestation of what was a disaster 100 years ago.
Jeff, it may be difficult for people to judge whether you made a mistake, but routinely in my courtroom we decide whether or not someone acted improperly when he broke and entered a dwelling house or committed murder or rape, and those are rather unpleasant things to think about. We routinely decide whether people are engaged in improper conduct of a wide variety of kinds, and it seems to me that you may be arguing that it is not desirable to decide whether people did some things that were unsatisfactory on a particular occasion, but I was only suggesting that it is something that can be decided. We have a mechanism for making that decision if we want to make the decision.
Right, but it's interesting that you pick as the examples where we do it where there's intentional wrong.
No.
Now, well, those are the examples you use, Dick, and I would certainly agree that deciding whether somebody raped somebody, deciding whether somebody robbed somebody is probably worth doing, although I'm not at all sure when we look at the criminal justice system it works out that way.
I suspect
On the
you
other
might
hand,
not be sure.
we've got an insurance mechanism with reference to civil wrongs, which is very different from criminal wrong, and I say once we've got an insurance mechanism, we ought to try to make it function as an insurance mechanism and not as an accusatory process, which chews up the insurance dollars, not paying victims, and not, I suggest, Bill, teaching the doctors very much. You may be a little more careful on your rounds, but I don't particularly want to have a senior professor at the Tufts Medical School more careful. I'm already spending too much money on him already.
Dr. Schwartz, I believe you have the floor.
One of the subjects that we hear discussed most widely in this country today in relation to the healthcare system is quality of care. Despite your comments, Jeff, there is a deep concern among the public and in Washington about the quality of care. Doctors are human beings, and apparently the public feels, and I suspect, looking at myself rightly, that we should be monitored in some way. The techniques for monitoring aren't very good. None of them are very good. Any solution to quality of care that you might propose or mention, I think we could find serious fault with. But that there must be such mechanisms, I think we're all agreed upon. The difficulty with the tort system may be significant, but the only way that we can decide whether we should be concentrating on trying to improve that system and make it work in a more effective way, or whether we should go to another system, is not to criticize it in isolation from the alternatives. The serious question is, what are the viable alternatives? The one that has failed, and that I predict will largely continue to fail, is regulation by the government of quality of care. Every time we try to regulate physician performance, whether it's through licensure or sanctions by some governmental board or PSRO, all kinds of unanticipated problems occur.
Doctor, since we've come to this point, let's go to a specific attempt to find some means and methodology to relieve the crisis. Governor BOWEN, in your state, in a marathon of negotiation and compromise, as I understand it, legislators, doctors, lawyers, hospitals, insurance companies, and consumer representatives found enough consensus to produce Indiana's Medical Malpractice Act of 1975. In April of 1975, you signed that bill into law when the ink was hardly dry, it is said. Now, what are its provisions and how is it working?
Well, I think that it's too early to really assess how it's working, but the provisions we will mention just shortly, but I want to stress, first of all, that we would never have gotten it passed had we permitted a cat and dog fight to develop among the insurance companies, the doctors, and the lawyers. We did get them all together, and we all decided that really this was not a doctor's problem alone, nor an insurance company's, nor an attorney's, but it really was the patients, the people's problem. First of all, our bill provides a residual market for those who could not get insurance. And usually those were the ones who were just graduating from medical school and internship and residency training and going out into practice. And insurance companies were not taking on new clients, so we had to have a market for them. We established three limits. A limit on the amount for which one could bring a suit, and that limit, or the total, is $500,000, 100,000 of it being insurance and the other 400,000 being a patient's maintenance fund. Second, it limited the length of time at which, in which a suit could be brought, and this was 2 years from the time or the occurrence of the malpractice, with the exception of children, and you can go clear up to 8 years, so that the child could be into school and you could assess any brain damage as a result of any birth injury. And perhaps one of the most controversial parts is that the attorney's fees were limited. It also establishes a medical review panel of 3 physicians and 1 attorney, and they have 6 months in which to develop their report, and the report is admissible in court itself. We also developed a reporting system for those who have been convicted of malpractice. All of the report goes to the medical licensing board so that they can withdraw his license if they feel that that is necessary. We established a continuing study commission so that they could do research and prepare amendatory legislation. And also the bill stated that guarantees of cure are no good unless they are in writing, because it's so easy for the doctor to pat a patient on the back and say, you'll be fine in a few days, and some of them consider that as a guarantee, I guess.
Let me see if I can comment on the approach that was taken in Indiana, and perhaps begin by asking the question, what is the problem that people are trying to solve? Because I'm not sure that the Indiana solution will work out to be a solution to the problem. That problem is broken into 2 pieces, it seems to me. One is an economic problem, and one is what I would call an emotional problem. The economic problem is that for some healthcare providers, the cost of insurance is a disproportionate part of their total income, so high a percentage that they cannot feel they can properly provide services. Certainly that is not an acceptable situation.
Dr. Schwartz?
Well, the problem is one in the way the insurance market is constructed. We've talked about the tort system and its problems, but some of those are potentially remediable. The difficulty is that most malpractice programs do not use so-called experience rating. That is, one physician can have a large number of claims and continue merrily about his business, paying exactly the same premium that his confrere in the next operating room is paying while having no claims. And I think that one of the problems with the system, in terms of its purpose, as I would see it, and as I quote others seeing it, is that we're not getting the signal to the right people. There ought to be lots more experience rating. Now, if a physician starts to have to pay 3 or 4 times as much as he's now paying because of his bad record, he has some options. He can improve his performance and not produce as much damage and therefore not have to pay as large a premium. He can go back to school, since it may be that he never learned what he should have learned, and try to improve his performance. Or he can have to pay for it, or he can get out of practice and quit doing whatever it is he's doing. In other words, we have a way of weeding out the incompetents if we send them a proper signal.
Say your piece, Judge. What do you
What I was trying to say before was that there is an economic problem, and there is, if an economic problem, some method of solving that economic problem so that certain physicians do not pay an unreasonable portion of their total income. There is an emotional problem in that some physicians are disturbed that they may be involved in this litigation. Rather than receiving the signal that Dr. Schwartz talks about, they are unhappy about it and therefore do not receive a signal, instead respond that they just don't want to have anything to do with the whole thing. Now, both of those problems can be addressed, and there can be sensible answers to each of them. I think to find some neat, slick response by inventing some new labels doesn't help anybody. I'm concerned with your approach, Jeff, that it is a neat, slick response.
One that's worked, though, in other areas.
Not here, and I don't think you can suggest. You haven't been able to sell this to any insurance company in the country. You know that.
How long did it take to get workers' compensation in this country? We had it in Germany in the 1870s. We didn't get a statute for workers' comp in the United States until 1910. You know, these things don't happen overnight.
I think, Professor, you should have time now to present the plan that you have proposed in insult to injury for extending no-fault insurance to medical malpractice, among others. So will you...
Sure, I'll try to do that. My basic proposal is to try to make the insured event much simpler. I think we've seen a graphic illustration of how complicated it is when we hear from people who think basically the present system can be adjusted and made to work, that people have to spend so much money defending claims under the present system that they are unfairly charged. We ought to allow the doctor or the healthcare provider of the hospital to look upon what the risks are. What are the risks of adverse results from this procedure? And let me see if I can take my present insurance dollar, which is being very badly used, and use it to pay people who are injured when these adverse results occur.
What is an adverse result?
An adverse result is what we lawyers have said the patient should be told about as a risk of the procedure in order to get his informed consent for the operation. That's a start. The medical profession has long lists of adverse results that they expect from given medical procedures. They don't undertake.
If the patient dies, is that an adverse result?
It may be, in a perfect case, it may be. What I'm saying is, why don't we let the doctors identify the adverse results that are actuarially predictable, and when they occur, pay for the out-of-pocket loss that the patient is put to once the adverse result occurs, rather than spending a disproportionate amount of the dollar arguing between plaintiffs and lawyers and expert witnesses and others over whether a mistake was made. In other words, let's simplify the insured event, as we did with workers' compensation, as we did with auto, and say when at least a simple, traumatic, predictable result occurs, and maybe we can gradually extend this to other injuries as well, we'll pay without regard to whether there was a mistake made. We will pay. If we can eliminate paying for pain and suffering, which we did with workers' comp, which we are doing with no-fault auto, and pay for out-of-pocket loss. Assurance of out-of-pocket loss in return for this chance at a jackpot of very large amounts in excessive out-of-pocket loss. And thirdly, I would allow the health care provider to be allowed not to pay to the extent that health insurance or sick leave has already been paid, because we've already got an efficient insurance mechanism picking up part of that loss. Why do we have this hugely inefficient tort mechanism now going to pick up that loss all over again? But I think it's worth experimenting to see if we can't have sufficient savings from lawyers' fees and insurance overhead, from payments for pain and suffering, and from payments that have already been made from sick leave and health insurance to finance paying people on a simpler basis.
All right, now, Governor Bowen, you haven't had an opportunity to say much of late, and you do have a program in being which has been going. Do you find any solutions to the many problems that have been raised by the other members of the panels, or any suggested progress in any of the areas in which they are in direct opposition in the program in Indiana as it has worked so far?
Well, as I say, thus far, it is too early to make any judgment, and I would agree with the professor here that it has not been constitutionally tested, and there are several points that certainly can be questioned, but we felt it was a pretty good bill because no one liked it, including the lawyers, the insurance companies, nor the doctors, and that's usually a pretty good sign that it isn't too bad a bill. The suits that were brought between 1930 and 1974 in Indiana, only 34% of them were brought in the first 36 years, and 66% of them were brought in the last 4 years. Now, this is the number of suits, I think, that caused some of the excitement and problem in Indiana, and of course it wasn't just in Indiana. But we feel that it will work if given a chance, and if those who do the testing of our constitutionality will be fair with it.
Dr. Schwartz?
If I may, Mr. Daly, I'd like to comment also on Jeff's proposal for no fault, because it sounds so attractive. It's really a very seductive proposal. You get rid of all these lawyers' fees and defense and so on. But I wonder if it's really quite that simple. First of all, with relatively few exceptions, as soon as we say that we will cover damages not only from negligence, but also bad outcomes that are unrelated to poor medical care, we're beginning to add to the expenses of providing the insurance. The second problem that I think you brushed over a little quickly has to do with whether or not we aren't going to simply have a new set of lawyers litigating a new set of issues, namely around causation. I gather from what some of my lawyer friends tell me that one of the things that plagues workmen's compensation is the issue as to whether a particular illness or injury is work-related or not. In medicine, the situation is 10 times worse. If we have someone, say, had transfusions and developed hepatitis, the question then is going to be, which of the blood transfusions given by which doctor caused the hepatitis? And did he develop it so many weeks after the transfusion so that we wonder if it could be due to the transfusion or is it due to something else? And if the patient is taking a drug for some other purpose which causes liver damage, could it be that it's that rather than the blood that caused the problem? And soon we will have the lawyers enjoying a great surge of new activity in determining the issue of causation. And finally, I do believe, speaking as a physician who teaches medical students, talks to physicians, makes rounds, that there is a strong deterrent effect from the potential problem of malpractice. If we go to a no-fault system, what we will have is a situation in which even if there is a very large increase in the number of bad outcomes due to carelessness because there's no signal to the physician, we've lost one of the important deterrent quality of care signals. If, on the other hand, we say, well, if you have more bad results than your friend down the hall, and we experience rate a particular physician, he simply starts avoiding doing those things which throw him into your no-fault category in which he knows there's going to be a high incidence of untoward results over which he has no control because they're not negligent, but which he has to pay for under a no-fault system. So you're caught on the horns of a terrible dilemma.
You say, for example, that a no-fault scheme is going to add on too many claims. But I think that overlooks, Bill, that if you do not have to pay to the extent that all sick leave and all health insurance is paid, you are eliminating a vast number of cases. Secondly, you suggest that there are causal problems. Of course there are causal problems. But that doesn't mean, once again, Bill, that we can't identify a great many relatively simple, traumatic, likely adverse events that we now predict. And when they happen, we can, in most cases, identify them as stemming from the medical intervention. There's going to be gray areas. There are gray areas with workers' comp. But nobody pretends that the problems with workers' comp, in terms of causation, in terms of litigable issues, is anything like what it is under the tort liability system. And let me just come to deterrence.
Jeff, before you do that, I think you're missing the major difference, the overwhelmingly major difference between this area and workers' compensation or automobile insurance or any of the other fields to which you've made reference and attempt to borrow some of your views. Here we're dealing with sick people who are treated and who may or may not have further problems after the treatment. And the problem typically is to determine whether the problems are related to the sickness or to the treatment. In the other areas, you're dealing with well people. You're dealing with someone who's riding in an automobile or working at a machine and who is no longer well. And it is relatively easy to say that that fellow who was well and is no longer well because of a specific single event that occurred. Here you're not dealing with a specific single event, but a course of care. And to say that the result came from the care rather than from the illness is a very difficult task, equally as difficult, if not more difficult, than the present problem of deciding right and wrong. Further, after you have made that attempt to decide, you then are saying, well, there are some things that one would be able to identify that are sufficiently clearly related to the care and not to the illness that we could pick those out. Well, what you're really saying is that those are the events which the tort system now picks out and says those are attributable to an error, because the difference between the error and the event that is sufficiently clearly related to the treatment is one that escapes my understanding at the moment.
All right, then let me explain it to you. The difference is that we now have to decide whether in this particular case the error was due to negligence. That's a very difficult decision. Is this adverse result likely to stem from this accident, whether induced by negligence or not? In toto, as a group, in insurance terms, in large terms, that's a very significant difference. For example, you could structure the definition of events for terms that are generally avoidable by negligence, but you wouldn't have to litigate in the particular case whether this doctor made the mistake. You could pick a traumatic, relatively identifiable event which may flow.
Now I think we have the heart of it. What you are now saying is that maybe really the whole proposal is that we take events that everybody can probably assume are negligent events. Amputation of the wrong arm, That's a negligent event. Everybody would agree. Okay, if we take that event, that's one we can schedule and say that's the one in which there's going to be payment, albeit at a much lower level than the individual is now entitled to payment. That he will not receive payment for what you call euphemistically pain and suffering. He will not receive payment for disability, disfigurement, or any of the other non-economic losses. Instead, you will say, because this is an event that we could characterize as an adverse result, and frankly also a negligent result, we're going to now be able to pay it easily, quickly, at 1/20th the rate.
I don't have any doubt that a court, with all the capacity of courts to eliminate conscionable contracts from unconscionable contracts, can wipe that out, and I don't think we need worry about that case. The question is whether we can identify in gross risks of procedures which are likely to occur, that when they occur we can say the probability is it stems from the medical intervention. We identified it prior to the surgery as likely to come from that, and therefore pay for it. And let me get to the deterrence point. Workers' compensation, no one can demonstrate, has resulted in less deterrence of unsafe practices by employers as a result of paying without regard to negligence. On the contrary, Holmes, in a very famous aphorism, said, if you force someone to pay whenever the adverse result occurs, he will be more likely to be careful than if he only has to pay some of the time.
If we have a housewife, Jeff, who likes to paint, looks after her family, gardens, sleeps well, enjoys life, goes to the movies, and she's seriously injured under your no-fault system, she now is in pain a good deal of the time for the next 3 or 4 months. She is not available to essentially in any way to her husband or children. She can't garden, she can't paint. What kind of award would you make to her? Is that worth nothing?
You bet your life it's worth it. And let me say that the no-fault system under workers' comp is an infinitely more compassionate system than is the tort system. Take the person who is finding that her manner of life in terms of her enjoyment of gardening or other things is curtailed, dramatically curtailed. When you deal with paying with medical expenses, the workers' compensation experience shows that the insurer has an incentive to get in there promptly and work on rehabilitation and try to get that woman back where she can move her arm, where she can function. What happens with the tort liability system? She will wait on the average 3 years before she has her claim decided. 3/4 of those cases will deny liability. If you want to cruelly treat people who are injured, subject them to lawsuits.
That concludes the first segment of our program. The problems of the economics of medical malpractice are not ones for which there are quick solutions. Is there merit, for example, to a proposal that states set up screening panels to try to reduce the number of malpractice suits that get into court? Is it possible that federal or state governments could step in to help doctors pay their insurance premiums or to pay malpractice awards? Could more be done to eliminate the causes of malpractice charges? Time now to get the views of our experts in the audience, who will question our panelists.
All right, may I have the first question, please?
Joseph Fastow from the Johns Hopkins Hospital Department of Emergency Medicine. Dr. Schwartz, from the physician's point of view, the potential for punitive action in the current system is clearly lacking, particularly in the financial area, where higher premiums are passed on to the patient in higher fees. With this in mind, what sort of a professional review mechanism do you envision for medical injuries? And second, what punitive actions, both professional and financial, do you see?
I think the difficulty is that the physician with a bad record in terms of a large number of claims against him and successful claims against him is not penalized as an individual under most programs. All people doing the same sort of thing may be penalized, but he as an individual is not. If he were experience rated, if his premium went up 200 or 300% in response to a bad performance record, then I think we get a very good signal, because he will not be able to pass on his selective increase in premium because of poor performance to a third-party payer or to the patient. The difficulty lies now in the fact that all physicians of the same kind have their premiums raised, and all the doctors who are not getting into trouble with negligence can properly go to the third-party payer and say, look, we're doing our best, most of us have a fine record, why should we be penalized? You must give us an increase in our rates for our services in order to cover the extra premium. So I think it brings us right back again to the problem of the absence of experience rating.
I think that if I could add a mere fact that the provider is a defendant and is found legally liable, even though he may not pay 1 penny of that liability, is to him a disturbing situation. And he would prefer not to have that. So that provider will make efforts to avoid that disturbing situation. And in fact, that has been the experience. This is in fact what some people call defensive medicine, a desire to avoid the potential liability, even if there is no economic cost to it at all.
Judge Marcus is absolutely right. The only signal we have in the system of any consequence to the individual physician is the embarrassment and time price that's exacted from him if he's sued. That is the key signal that he faces. Oddly enough, ironically enough, the importance of that signal is diminishing as more and more physicians are sued. There's less and less social disapproval of a physician in response to a suit. So one of the curious consequences of the rising number of suits is that that signal is being attenuated and weakened as we move along.
Well, can I make a comment on that to indicate how complicated it is? The New York Medical Malpractice study indicated that the doctors who had the most claims against them were the best doctors.
But I've heard that aphorism a number of times, and it seems to me there are lots of ways of interpreting that particular phenomenon. One is that the best doctors get the most difficult cases with the most visible bad results, and that they are therefore more likely to be sued. And I believe that before we abandon the existing system without trying to improve some of its shortcomings, that we better be pretty sure that what we're getting into isn't worse than what we have, so that it's a matter of comparison of which is the least bad system, rather than any enthusiasm on my part for the tort system or any other.
So you're not at all enthusiastic then about merit rating or more refined rating. You just throw that out as maybe a possibility.
No, I am enthusiastic about that within the tort system. What I was trying to address was the question as to whether the tort system, with all its faults, is better or worse than such alternatives as you propose, and I don't think there's a clear answer to that at the moment.
Governor Bowen.
I am a strong believer in the professions policing themselves, and we have two methods by which this can be done. One is through the associations themselves, and secondly, when we do have an individual who has been declared guilty of malpractice, by law in Indiana, that whole record goes before the medical licensure board to determine indeed whether he should even be allowed to continue to practice. And I think that we need to stress a little bit more in all the professions of weeding out those who should not be practicing at all.
Let's go on to another question, please.
I'm Clark HAVIGHURST. I teach law at Duke University. It's widely alleged that doctors, because of their fear of malpractice suits, practice defensively. I'd like Governor Bowen to discuss whether or not that is in fact the case and what it means. And then I'd like Dr. Schwartz to tell us why the incentives that he thinks the tort system supplies aren't in fact counterproductive, in that they produce care that is really excessively expensive and not really in the patient's interest.
Governor Bowen.
I would have to agree that most all physicians do practice defensive medicine, and I don't know why they shouldn't really given the present circumstances. I don't think there's any question but what too many lab tests are ordered, and this runs up into big money. But again, in the event that even the patient has had perfect care, that something goes wrong and he is sued, then most certainly in the courts will come up, did you do such and such a test where you might have detected this 1 in 10,000 chances that something might have gone wrong. I think that the physicians perhaps are using too many lab tests and not enough judgment, but I'm not going to fault them for it simply because of the tremendous risk of being declared guilty of malpractice if you haven't done all of that. And I don't know who's going to find the answer to that one.
Doctor?
The very critics of the tort system who say that there is no deterrence signal from torts quote defensive medicine as one of the bad effects of the existing liability system. I don't think that they can have it both ways. If in fact there was no deterrent signal, why would physicians practice defensive medicine? One of the most important criticisms that we hear is that billions of dollars are being wasted as doctors practice defensive medicine. It seems to me that's the single most impressive, objective piece of evidence, independent of my personal judgment as a clinician or someone else's opinion, that physicians as a group are getting a signal of some sort because they certainly are worried about the problem of a suit, and to deal with that, they are practicing what is called defensive medicine.
Can I add a comment?
Just a problem to the whole area. Although I certainly understand and agree with part of what each of you have said, there is a great difficulty in determining which part of these extra costs are related to the concern about professional liability, legal liability, and which part is related to the fact that the patient isn't paying the bill. The overwhelming, I think, single source for the performance of what may be unnecessary tests or examinations is the fact that the patient doesn't pay the bill. So he doesn't object. It is paid by a third person, either a government or an insurer. And as a result, the physician is encouraged to do everything he can think of, and the patient is encouraged to make sure that he does everything that the physician can think of, because he'd just as soon have everything anybody can think of too, since he's not going to pay the bill. This is a problem anytime you have third-party payment for expense.
But it also represents another distortion in the response of the system, in the sense that if a doctor is not spending as much time on a particular problem or patient, or isn't going to the library to get caught up on the latest relevant information about the disease, he may find that he can substitute to him no-cost laboratory tests instead of doing more on his own. In other words, it's not only that the patient doesn't have to pay, but the doctor doesn't have to pay. So to the extent he can substitute society's resources through third-party payers for his own additional efforts and time, he will always choose to spend naturally enough, so that every time we talk about the problems with the system and start looking into what the nature of them is, we find out that there are a whole series of underlying distortions which are influencing the system in such a way as to lead to lots of problems which are not necessarily part of the basic liability system.
Well, I'd like to come in, since we're in this area, and it's an area which I'd hoped to raise initially in the general discussion. The current issue of the Mayo Alumnus, which is published by the Mayo Foundation of the legendary Mayo Clinic in Rochester, Minnesota, has a startling pattern of statistics. It says, as of January 1st, 1976, there were 1,603 medical malpractice cases calling for $656 million in damages pending in Illinois' Cook County Circuit Courts. 3 to 4 new cases were being filed daily, and in the past 2 years, 79 of 90 Cook County hospitals and no less than 1 in 5 county MDs were being sued. But Judge, I guess particularly, would you have to say to what is inherent in this claim is that there are many frivolous suits being filed, and the medical doctors ought to start suing right back again?
Well, first, I think that some of the statistics that we have heard thrown about may not be as accurate as we might suspect. The last statistics that I saw were collected by the National Association of Insurance Commissioners, who are the regulatory agency for every state. And they required every insurer who writes medical malpractice insurance to report every case that they closed. The number of cases that was closed from 1975 mid-year to 1976 mid-year was approximately, and these aren't lawsuits, these are claims, were approximately 18,000, which is not a strikingly dramatic number for the whole country for a whole year. At the same time, you've raised a different question, which is, should there be a right of the physician to assert a claim when he has wrongly been accused? It's a complicated legal issue, and I think the answer may vary between different states. What philosophically should be the answer, I don't know. I think the courts and the legislatures will have to decide that. The real question is, how much risk do you want to put in litigation on either side? Do you want to say that the person who loses will have an even greater risk than he already has? The English have a different answer than we do because they say yes. Generally, our answer has been we do not want to reduce the availability of the courts by making the risks or the stakes even higher.
Next question, please.
I'm Dr. Reed. I'm another hybrid physician attorney. Professor Connell, I've been terribly disturbed by the overly simplistic solution you seem to have to the very complex problem we've been discussing tonight. But I wonder if you could clarify for us how your compensation system might equitably differentiate between damages awarded for the loss of fingers from the right hand of a taxi driver vis-a-vis a concert pianist.
Sure, I'd be glad to. What I'm saying is that we ought to use an insurance mechanism that pays for out-of-pocket loss, because that's relatively simple to determine. Of course, it means that we don't pay for psychic loss, and I will agree there is psychic loss from an accident. My basic point is that trying to litigate who's at fault and what is the monetary value of non-monetary loss makes for an incredibly complex insured event. In the case of the taxi driver, I would pay for his out-of-pocket loss. If he needs a prosthetic device to learn how to use a car with a prosthetic device on his hands, I would pay for that. If he finds he's in psychiatric difficulty because he can't drive a car, I can make a case that that could be easily convinced, I would pay for some psychological or psychiatric help. In the case of the concert pianist, I would not pay him for all of his loss, as we don't under workers' compensation, and we don't under no-fault auto insurance. We pay for a maximum about $1,000 a month on the assumption that a concert pianist has probably already insured his hands, should already insure his hands. As far as the concert pianist's psychic loss, once again, it's a tragic and terrible incident if he can no longer play the piano, but it would be a terrible and tragic thing if he could no longer play the piano from any number of accidents. And I would not single out the medical malpractice situation to shower him with money which cannot possibly replace his real loss for not being able to play the piano.
Does anybody else want to go to this? All right, next question, please. Yes, sir.
I'm Roger Platt. I'm an internist from New York. I'd like to ask Dr. Schwartz a question about the number of tests and the proliferation of services that might develop under a strict tort system where the physician is expected to do everything for the patient of marginal utility when that marginal utility is defined by medical experts. Do you think there's a significant risk that requiring physicians to do everything of marginal utility will dramatically increase the costs of medical care?
Well, I think you're touching on a very sensitive point which somehow hasn't arisen during the panel, and that is the perception of many physicians that they are being sued and are being found against, being found negligent for a level of performance which is above the negligence standard but doesn't represent everything that they could possibly do to help the patient. Now, as I understand the negligence law, it involves meeting the usual and customary standard within the profession. There are many physicians who claim that they are being sued whenever the outcome is bad, whether or not they have met the usual and customary standard, and in fact are thereby being forced to do more and more in order to respond to the excessive standard that's being imposed upon them. If indeed we expect the physician to perform well above the usual and customary standard and are going to hold him responsible if he doesn't, And if we make third-party payers' resources available for him to perform at that standard, namely well above the negligence standard, then I think we can expect costs to go up enormously. And I think it's time we really had a hard look at the question as to whether the courts are imposing something like strict liability on physicians or expecting more of them than under the negligence standard. And I don't know what the facts are on that. Perhaps Judge Marcus can comment on it.
It's a fair question, and nobody can give you an answer unless you sit through each of the trials to judge yourself. And unless you're willing to be on the jury of every one of those cases, you can't possibly know whether the decision was a fair one. I can tell you that statistically, the claimant, the plaintiff, the patient, loses about 4 out of 5 of the cases that are tried. So that if that's any indication, it would seem that they're not being subjected, that is, the physician's not being subjected to a fantastic standard of responsibility. There is an assertion made that the courts are quite willing to have the physician responsible in every case. That statistic certainly doesn't support that conclusion. From what I personally have observed, most courts follow the rules which are laid down by the upper courts, and that is that a physician is responsible only if the patient can prove by a preponderance of the evidence, the greater weight of the evidence, first, that the physician was negligent and did not follow the standard of care of other physicians in a like situation, and second, that the damage resulted from that negligent error, which are, those two propositions are frequently difficult to demonstrate.
Well, I would say that after more than 5 years of earnest effort and a good deal of debate, it would appear that the malpractice dilemma is properly defined by Webster as a choice between equally unsatisfactory alternatives. However, perhaps in the Indiana experience, certainly in the proposals put forward by Professor O'Connell and others, it is possible we see somewhere down the road ahead of us some solutions of real merit. This concludes Public Policy Forum, presented by the American Enterprise Institute for Public Policy Research.
This Public Policy Forum on the Medical Malpractice Dilemma has brought you the views of 4 eminent experts in that field. The program was presented by AEI, the American Enterprise Institute. It is the aim of AEI to clarify issues of the day by presenting many views, in the hope that by so doing, those who wish to learn more about the decision-making process will benefit from such a free exchange of informed and enlightened opinion. I'm Peter Hackus in Washington.
This Public Policy Forum series is created and supplied to this station as a public service by the American Enterprise Institute, Washington, D.C. For a transcript of this program, send $3.75 to the American Enterprise Institute, 1150 17th Street Northwest, Washington, D.C. 20036.